Choi, the founder and president of ChoiTechAndLaw Professional Corporation. Our firm is an intellectual property law firm in Canada that provides legal advice in all intellectual property related matters and patent and trademark agency services. In this video, I will talk about what you may consider when filing a patent application. Before filing a patent application, our firm can advise you on your patent filing strategy to ensure that it fits into your overall business strategy. Patent rights are jurisdiction-based. The rights associated with a patent granted in a specific country apply only in that country. Therefore, one of the questions that you need to consider is where to file your patent application. To answer that question, you may consider which markets you plan to target for your invention. What is the size of those markets? Where would you manufacture the products? Where is your competition? Do those countries have an adequate intellectual property enforcement system? And many more. After identifying the countries where you are interested in filing a patent application, we will advise you on the various filing strategies and the cost and time associated with each option. Canada is based on a first-to-file system, so file your patent application as soon as possible to ensure that you secure the earliest filing date for your application. Otherwise, someone who files a patent application ahead of you on the same invention will be entitled to be granted a patent and not you. Sometimes, you may need more time before committing yourself into filing a patent application in certain countries, and there are many different reasons why you may want to do so. Regardless of the reasons, we invite you to contact us to discuss some of the options that may be available to you without jeopardizing your rights to file in those countries at a later date. We will also walk you through the process of filing a patent cooperation treaty application, or usually called a PCT application, which is an international application if that is the right option for you. Next, before you publish an article about your invention, present your invention at a conference, display your invention at a trade show, sell your invention, or discuss your invention with anyone, you should first consider having a non-disclosure or confidentiality agreement in place. We will be happy to assist you on that as well. In Canada, you have a 1-year grace period from the time you disclose your invention to the public to file a patent application. However, in certain other countries, there's no such grace period. Therefore, you may lose your right to obtain a patent in those jurisdictions. Another question that you may consider is whether you need to appoint a patent agent in Canada for your patent application. The answer depends on whether the applicant is also the inventor of the patent application. If you are both the applicant and the inventor of the patent application, appointment of a patent agent in Canada is not required by the Canadian law. However, if the applicant is not also the inventor of the patent application, then according to the Canadian law, it is mandatory to appoint a patent agent in Canada. For example, if the applicant of a patent application is a company, but the actual inventor is an employee of that company, then the company must appoint a patent agent in Canada to communicate with the Canadian Intellectual Property Office on all matters relating to the patent application. Obtaining a patent could be a very time-consuming and complicated process. By appointing a patent agent in Canada like our firm for your patent application, we will assist you to comply with the Canadian patent law, to observe all the prescribed deadlines to prevent losing your rights from obtaining a patent, and to work closely with you to obtain broad protection for your proposed invention where possible. Next, if you are a non-resident applicant on the date you file a patent application in Canada, you would also need to appoint a representative for service. The representative for service can be a person or a firm that resides or conducts business at a Canadian address. Usually, the patent agent is also appointed as the representative for service by the applicant. To recap, remember that time is of essence. Without a non-disclosure agreement in place, avoid public disclosure of your proposed invention prior to filing your patent application. Consult an intellectual property lawyer to prepare confidentiality or non-disclosure agreements before you disclose your proposed invention to anyone. File as early as possible to maintain your right to file a patent application. Decide in which countries you'd like to file your patent application, and discuss with your patent agent about your various options and filing strategies to support your overall business strategy. And of course, we are always here to help. If you have any questions, we invite you to visit our firm's website at www.ChoiTechAndLaw.com or give us a call at 1-613-777-1088. We will be pleased to assist you in protecting and enforcing your intellectual property rights and in taking care of all your intellectual property needs, including, of course, working with you as your intellectual property legal advisor and patent agent to assist you in getting your patent registration and enforcing your patent rights. Thank you.